Hi, thanks for tuning in. I want to go over the inherited powers of a commissioner, a referee, and a judicial officer in regards to a contempt proceeding. Now, I was digging into my crates basically. This is from 2010, but it's still relevant. There may be some revisions in regards to some of the contempt proceedings, but pretty much for the authority of a commissioner, in some states they call it a magistrate, they are of limited powers and they cannot adjudicate contempt proceedings unless you stipulated from the beginning them to hear your child support case. And that's another bag of worms I want to get into. But it's very good if you get this information. If you're in California, this is pretty much pertaining to California because that's all I know. I don't know about any other state, but every state does have this under the Constitution because you have to be a judicial officer, a judge that has his oath and bond to adjudicate such powers under the Constitution of your state, especially in California, and as well as the United States Constitution. So you can look that up as well. But anyway, this is courtroom control, contempt, and sanctions. And what I'm going to go through, I'm going to look for, as the whole purpose of this video is for commissioners and referees and judicial officers. And it's like I said, for the record, I am not an attorney. I am not a paralegal. This is information I want to share with you guys all. I wish in my time when I started this whole nonsense, I wish that somebody would had helped me, informed me in regards to information from my case. And when I was going through my contempt, I wish I would have had some more case law in there, but overall it was dismissed. I had two contempts, one for my ex, for attorney's fees and all this nonsense and all this bunch of BS. But that case was dismissed, and then the child support, they were harassing me. So basically that was ended up dismissed because I cited the anti-peonage law and the anti-slavery. But what I know now, I want to give this information, this valuable information to you guys so that you can be able to do your research and then tackle these issues at hand that you're facing. And also too, when I started, sorry, you don't know, but when I started involving myself with different advocacy groups and support groups, it really helped me a lot as far as to getting information, challenging information. Because before I was complacent. I didn't know where to go. I had two attorneys. They sold me under the bus, basically took my money, and I'm gonna get them. After I finish what I'm doing with my case. And then also, I was part of, a documentary, which, it's called Divorce Corp, CORP. I'm at the end holding the sign, Reform Courts Now. That's me. And basically, it really helped me get through this, I was, and then also, too, recently, I started, involve myself with, other YouTubers, because at first, I was like, you know what, I'm going to put my case online and spread the word, show the corruption that I'm facing, and come to find out, everybody's facing the same thing, it's like the same story, but different actors, basically, that's all it is. And, it's I call it a big judicial mafia, and and they're just laughing at us and destroying people's lives and stuff. So, anyway, I want to give this information to you so you'll be able to research for yourself if you're going through a contempt with a commissioner, because oftentimes for child support, it's a sitting commissioner, not a judge on the case. And the key word is stipulation. See, if you don't stipulate, if you don't agree to sit before the commissioner on your case, you have the right to object to be heard before a commissioner. Because if you don't object, from what I read from here, is that if you don't object, you basically agreed by default, and then they can inherit these contempt powers against you in regards to failure to pay, of course, contempt for, order to show cause, that why you disobey the court order, is a quote unquote order. But the commissioners, they can file contempt against you, or sanction you rather, if you disobey the court decorum, disobey the court, outburst, telling the judge off, strolling in late, how you feel like it, whatever. So they have those contempt powers, but to enforce an action as far as like a civil quasi contempt proceeding for failure to pay, there has to be a stipulation before the court that both parties did agree to be heard in front of a commissioner in order for them to have inherited powers. And I'm going to show you in this bench guide, which is basically their Bible and their script, basically, in adjudicating these cases. So anyway, so I'm going to read here, and it says, okay, limited authority of commissioners and referees. Okay, this is section 322 of the California Bench Guide from 2010. And I don't have a recent one, but this is all relevant today. So anyways, no inherited contempt power. Commissioners and referees do not have inherited contempt authority or the broad statutory contempt powers possessed by judges. See California Code of Procedure, section 259. Government Code, section 72190. And here is some case law. Marcus versus Workmen's Compensation Appeals Board. Decided before enactment of Labor Code, that's, LAB, section 5309C, authorizing delegation of contempt authority to workmen's compensation judges. The list of statutory powers of court commissioners in California Code of Procedure, section 259, for example, does not include contempt. Furthermore, although a judicial officer may punish for contempt in the case provided in the Code of Civil Procedure, that means disobeying the court, basically telling the judge off and outbursts and talking out of turn. There's a whole list of things, and so that's what a judicial officer or a commissioner has the power to do. That's under California Code of Procedure, section 178. The term judicial officer, quote, does not include a commissioner. See Election Code, section 327, and the Code's general contempt provisions limit the power to a judge or court. See California Code of Procedure, sections 209 through 1222. Okay, so it's a long thing, so I'm not going to read the whole thing, but I want to give you the key information that, I think will be beneficial for you. And then you can just read it on yourself. Okay, let's see. Here. Service as temporary judge under stipulation. So now, if you stipulate to be before a temporary judge, when you go in, they say, we're temporary judge Mr. B, and then if you sit there, you're like, okay, all right. So basically, you're saying you agree to have this temporary judge hear your case, and when you agree that basically they can do a contempt proceeding against you, which is child support in a sense. So basically, there has to be a stipulation for a temporary judge, or a pro tem judge to hear the case. It has to be in writing. So I'm going to show you too some examples, which is on our California Judicial Council form, and this is what basically put on this document here. But I want to show you what they have to have this on the record in order for them to proceed on or adjudicate any contempt actions against you. So anyway, under section 323, service as temporary judge under stipulation. The contempt authority of a commissioner, referee, or pro tem judge who serves as a temporary judge on the party's stipulation under California Constitution, Article 6, Section 21, depends on the situation and the terms of the stipulation. Unless the stipulation includes a specific authorization to adjudicate contempt matters, no authority to adjudicate a contempt in a separate or ancillary proceeding is granted. See Sacrosino versus Superior Court. And these are all California case law. So this may not apply to your state if you're talking about contempt action, but you can look up the case law if you go to your local library or to Google Scholar and for your state. Just search contempt powers of a magistrate, or contempt powers of a judicial officer, contempt powers of a commissioner, and you'll find some case law in there. So anyway, so contempt proceedings may be seen as ancillary to principal action in re Fry 1983. This is case law here. Absent proper stipulation, that means absent proper agreement between the two parties, that means you or your ex-wife or husband, commissioner lacks authority to hear and determine contempt proceedings, and any order of contempt is void. And see, now, I wish I would have known this when I went through my contempt, because I didn't know, I knew my case was wrong, but I didn't know that my whole case was null and void, and it's still null and void. That's why I think that they're just pretty much harassing me, and they haven't been taking me to court lately. And so basically, here, again, absent proper stipulation, commissioner lacks authority to hear and determine contempt proceeding, and any order of contempt is void. That means it's zero, nada. However, because a commissioner, referee, or pro tem judge who acts under stipulation, so if you agree that the pro tem judge, the commissioner, and the referee can hear your case, that's what they're trying to trick you in there, then they have full judicial powers, full judicial authority until final determination of the case. See California Constitution, Article 6, Section 21, and Remark L, 1983. And this is the California 3rd District Appeals Court here. And then it goes, he or she may adjudicate a direct contempt if the adjudication, I can't even speak now, adjudication, takes place before the case is finally determined, and if the contemner stipulated to the commissioner, referee, or pro tem judge. And that's Fine, which is Richard Fine, versus Superior Court 2002. No express authority to issue contempt orders need be granted in stipulation. The authority is inherited in court's power to exercise reasonable control over its proceeding under the California Code of Procedure, Section 128A and 3. And this is the C discussion in Rothman, California Judicial Conduct Handbook. So then I want to show you their sample of they have to have on file when they do their contempt proceedings. Okay, so here's the sample here. Now, sometimes you guys receive like an order or some kind of threat in the mail that you're hereby ordered to appear before the above title courtroom. This is nothing but cut and paste stuff. They use it on the judicial counsel form. But this is what it basically says. You are hereby ordered to appear before the above entitled court in department, whatever it is, located at whatever, California, blah, 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 to show cause of any why you should not be adjudged guilty of contempt of court and punished accordingly for the acts of willful disobedience of the order of the above entitled court, blah, 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 Section 1209, right, of the California Code of Civil Procedure. And then it goes, it's supposed to be signed by a judge, and oftentimes it's not. It's by a clerk or, some scribble or some stamp that you can't recognize, and no, not even a seal. And then look at here, written form, statement of facts of commissioner referee. So with this referee or commissioner who's holding you under contempt, listen here, let's say Commissioner Bogglehead states as follows: I am blank judicial office, that is commissioner, whatever it is, would be their name, comma, commissioner of the Superior Court of, let's say, Sacramento County in California. And then we have the direct or hybrid contempt. I didn't go over that because it's very long, but it says over here, it says on date XYZ, case number, blah, blah, while serving as temporary judge on stipulation of the parties under Article 6, Section 21 of the California Constitution, in the immediate view and presence of the court was alleged contemner, blah, blah, said the following. So this is what they use. This is what they use to they have to have it on file when they file the contempt. It has to be a stipulation. So don't get caught up in the matrix. And if you're in California or if you're in your state, make sure you get a bench guide. That's very important. Until next time, Um, have a good day.